used ones.
I'll get rid of it.
All right, the crowd keeps getting smaller.
Wonderful, thank you.
Let everybody take their seats. Selma's here, Scott's here. Okay.
The faithful remnant.
All right, ladies and gentlemen. We're now at the panel that's going to focus on dispute resolution. A contentious point, a storied history under Nafta, and we have the real experts here to talk about it. Our moderator today is Maureen Irish. Okay, Maureen is a professor emeritus at the University of Windsor's Faculty of Law, and she has taught all types of courses on international trade law and international economic law, international business transactions, Canada-United States legal issues, and many more. Most importantly, she has also served on panels under the Canada-U.S. Free Trade Agreement dispute resolution provision and the Nafta dispute resolution provision. So she's seen it from the standpoint of deciding disputes. So, Maureen?
Thank you very much. So this is the panel in which we figure out how to settle disputes. So we've had many comments and views throughout the day, and this is the specific focus of our panel that will resolve all of this, perhaps. Or I'm not sure. It's a little difficult to figure out how we decide the measure of success of dispute resolution. You know, does the success of dispute resolution mean that things are quiet? That's okay. Sometimes that's all right politically. Does it mean that we've had a lengthy discussion and we've been through all the issues, we've got everything solved, and we now have wonderful systems that go forward? Does it just mean that we get, you know, some kind of final resolution of that particular dispute? Or there may be any other measurements of success for dispute resolution. And of course, there are lots of different ways in which the methods of dispute resolution can be addressed. So to get us going on all of this, we have two panelists with expertise and experience in the private sector and in government relations. Donald McCrae is on the program. Don is unfortunately unable to be with us because of illness and sends his regrets. I'm going to introduce these speakers briefly for the record. You will have further details in the conference materials. And then our two speakers will speak in order, and then we'll have lots of time for questions and comments and any solutions that we might not have thought of. So our first speaker will be Scott Miller, who is Senior Advisor at Abshire Inamori Leadership Academy at the Center for Strategic and International Studies. He focuses on leadership development programs for public and private sector executives. Until 2017, he held the William M. Scholl Chair in International Business at CSIS. The chair focuses on critical issues in the global political economy, including international trade, investment, competitiveness, and innovation. In 2015, he authored Investor State Dispute Settlement, a Reality Check. Prior to joining CSIS, he was an executive with Procter & Gamble, a leading consumer products company. He has also been involved in a range of international trade, investment, and business facilitation issues and campaigns supporting U.S. free trade agreements and has been a contributor to U.S. trade and investment policy over many years. He's a member of the State Department's Advisory Committee on International Economic Policy and was the founding chairman of the Department of Commerce's ITAC Investment Working Group. Selma Lussenberg, until just very recently, served as Vice President, Governance, General Counsel, and Corporate Secretary of the Greater Toronto Airports Authority, Toronto Pearson International Airport. In this role, she led a team of more than 90 people providing advice and direction to the Board of Governors, executive team, and the organization on governance, policy compliance, security, corporate safety matters. Previously, she served as chair of the Ontario Capital Growth Corporation, the Ontario government's venture capital and private equity business. She has also been Senior Vice President and General Counsel and Corporate Secretary at OMERS, one of Canada's largest public pension plans, and also Vice President, Legal Affairs and General Counsel at AT&T's AT&T's Chief Regional Counsel and Corporate Secretary at AT&T Enterprises and AT&T Global Services. She is currently a Canadian private sector representative to the Trade Minister's Nafta 2022 Advisory Committee on the Resolution of Private International Commercial Disputes and the Canadian chair of the Nafta 2022 Transportation Sectoral Working Group. So, two panelists with a great deal of background and expertise, and I will first call on Scott.
Thank you. And let me add my thanks to the United States Law Institute. It's been a pleasure being here. I just mentioned to one of the previous panelists that I learned more in the last hour and a half on NAFTA automobiles than I learned in the previous year and a half sitting in Washington. So this was very beneficial from that standpoint. But I'm delighted to be here and happy to be a part of this. There are basically three dimensions of dispute resolution in the NAFTA. We've talked before, but let me go through the taxonomy. Chapter 19, which is somewhat unique. I start with Chapter 19 because it's sort of the one that's really unique to the U.S.-Canada relationship. It comes out of some very specific U.S.-Canada politics and continues in that manner, but it doesn't really exist in any other U.S. agreements. And so it's somewhat sui generis. Chapter 20, which is, I think, more generally state-to-state dispute settlement, which is consistent with U.S. free trade agreements with other economies. Most of them have a chapter that's similar for resolving disputes between the parties. And then there's Chapter 11, which is the investor state, or Chapter 11 are the obligations for the treatment of investors, which has the investor state dispute settlement mechanism. I want to save that for last because it is the one that has the most general problems in that I think there's a broader context of the erosion of legitimacy for investor state dispute settlement in a broad-based nature, goes well beyond NAFTA Chapter 11. So let me take them in the order, sort of, we'll go from narrow to broad, if I could. We've already had a lot of discussion today on Chapter 19. Chapter 19, of course, is the provision affecting trade remedies, and thanks to Peter Clark for spending time on his panel talking about the from whence it came. Let me just make a couple additional points about Chapter 19 in the current NAFTA context. First, given our U.S. trade representative's personal characteristics, one, he's a trade lawyer, has for 30 years been practicing trade remedy law, and second, his political mentor was Senator Robert Dole. Ambassador Lighthizer was trade counsel on the Senate Finance Committee for when Bob Dole was the chairman of the Senate Finance Committee. But he has a very close relationship with Senator Dole. He was the Mr. Lighthizer was the finance director of the 1996 Dole for President campaign. So the fact that he subscribes to some of the sovereignty concerns of his political mentor, and the fact that he's a practitioner of trade remedy laws and is suspicious of non-U.S. persons having any role in a U.S. legal proceeding shouldn't be surprising. So that's kind of how it got tabled, at least in my view. The one thing I would add that hasn't been said today on Chapter 19 is there was a massive missed opportunity to do something practical on Chapter 19 that I think we've now walked past it. And it's this. And I cite the data from Jeff Schott's colleague at the Peterson Institute, Chad Bone, because Chad looks a lot at sort of what goods are subject to trade remedy laws from which economies, and he tracks it over time. So the 5 years before Donald Trump, so call it 2012 through 2016, it was a very quiet period in terms of disputes in the United States that wound up with trade remedy filings and affected Canada. So here was what Bone reports, that of U.S. anti-dumping and countervailing duty cases from that 5-year period, only 1.3% of NAFTA imports were affected by those dumping orders, okay? Relatively small. Now, one of the reasons it was a quiet period is because softwood lumber was quiet then, all right? And this, this tends to, when you scrape away enough at trade remedy concerns between the U.S. and Canada, the bedrock is softwood lumber. You always find it, okay? It's not a surprise. But this was a quiet period, and so only 1.3% of NAFTA imports, that includes Mexico, Canada, to the United States, were subject to any kind of anti-dumping and countervailing duty order. At the same time, Canadian application of trade remedy laws had similar kinds of figures. Only 0.1% of NAFTA imports were affected by Canadian dumping orders in that same 5-year period. So we had this period of time when trade remedies weren't really causing a lot of political heartburn. And if we wanted to do something about Chapter 19, that was the moment to do it, but it didn't come up. What happened subsequently? Donald Trump won. He and his team turned our trade remedy actions, as the boys from Spinal Tap would say, up to 11. And all of a sudden it's controversial again. All of a sudden it's heartburn for Canadians who are swept up in sort of caught in the crossfire of U.S. self-initiated anti-dumping cases. So we've once again, Americans have snatched defeat from the jaws of victory, but I think we're past that now, and it's going to have its own dynamic in the relationship. Just as a final point, it's personal for Ambassador Lighthizer. This is something he believes very deeply. So in any case, enough about NAFTA Chapter 19. I hope we'll have some questions. If we do, there'll probably be some people in the audience with answers. Chapter 20, and while Selma will have the greater expertise and experience on the practical operations, I did want to make one point on the operation of NAFTA Chapter 20 as far as resolving state-to-state disputes about the NAFTA. And that's that the U.S. did a very bad job early on. That I think U.S. behavior in the early cases, especially Mexico trucking, really demonstrated that this was not a dispute settlement mechanism where Canada and Mexico were going to get satisfaction. Look, you can go back and read the ugly history of the trucking disputes, and they got ugly very quickly. But this was a circumstance where, beginning with the NAFTA Chapter 20 case and moving on all the way to the U.S. Supreme Court, Mexico did nothing but win their argument in dispute settlement, and the United States said, yeah, we're not going to do that, basically. and that I think had an effect on the interest of any of the parties bringing cases. So I would just note that while NAFTA Chapter 20 still is in force and it still has effect, there's an opportunity to forum shop, and the forum shopping tends to favor the WTO. I'll point out two cases. First, the U.S. case on Canada's patent term laws could have been brought as a NAFTA Chapter 20 case. Instead, the United States brought it as a TRIPS case in Geneva. Likewise, when there was a country of origin of meat labeling issue in the United States, Canada and Mexico, both were the aggrieved parties, could have readily brought that into NAFTA Chapter 20, but instead went to the WTO and won the dispute. In both cases, the complainant prevailed, as it usually happens, and this is, I think, because partly we got off, the U.S. made sure NAFTA Chapter 20 got off to a bad start in our behavior early on, but I think also that was a period of time when the United States was very interested in showing respect to the WTO dispute settlement process, to actually complying when it lost, which we did in the country of origin case. And, I mean, I remember a day where the United States was sufficiently concerned with appearances in WTO dispute compliance that the Congress changed our tax law. This happened in 2006. It's the Fisk case that Jeff brought up. So we actually changed our tax law to comply with the WTO dispute. I don't know what we do today. I have an idea, but in any case, the NAFTA Chapter 20, I think, deserves consideration of whether its current form and the ability to form shop, given the similarities of obligations under the NAFTA and the WTO, whether it has a lot of future for handling state-to-state cases. So with that as opening comments for Chapter 19 and 20, let me turn to Chapter 11. And this is the context that I'm frankly concerned about, both in terms of the NAFTA and more broadly, which is that I think going as far back as almost 20 years ago, there was the failure of the OECD's multilateral investment agreement, which happened, so call it 1996 or 1997, where that effort fell apart. Now this is, of course, 1996 was the tail end of sort of the heyday of international investment agreements. At this point, there were about 2,400 of them in force worldwide. They seemed to be very popular. The ICSID convention had over 136 signatories at that point in time. So there are lots of good things going on in the world of treaty-based investment, and the OECD laid an egg with the multilateral agreement on investment. But that really began or gave voice to or gave traction to a lot of vocal opposition to the process of investor-state dispute settlement. Now, let me quote the great U.S. political commentator Michael Barone. Michael Barone says, "All process objections are insincere, including this one." And he's absolutely right. So there was a lot of process objections about ISDS. There still are to this day. Most of those process objections are framed as sort of a special deal for big business. It's an end around legal systems, whatever it might be. But those process objections hide a tacit objection to the substantive obligations that are about investor protection, which is, I think, the bigger concern. During that time period also, one of the reasons these criticisms gained traction is that the users of the governments who had negotiated and implemented these agreements failed to defend them vigorously. Right? And I noticed that started to happen when capital exporters started to become respondents in investment disputes. Those capital exporters, including the United States, got a lot more concerned about their defensive interests and a lot less concerned about the rule of law and the importance of protecting their citizens abroad with investment treaties. So we wind up with elected officials. We wind up with a moment that reminds me of the G.K. Chesterton's comment about this parable about the gate. There's these two reformers walking through on a country lane, and they notice a gate that doesn't seem to do much of anything. And the younger reformers said, "Well, this gate's useless. Let's tear it down completely." The older reformers said, "Wait a minute. I want you to go away and think about why somebody put that gate there. And when you can come back and explain that to me, then we'll talk about tearing it down." All right? And that's really what happened to our elected officials. They forgot about how bad things were for the treatment of aliens in the 60s and 70s. They forgot about, what was happening in the United Nations and elsewhere. They forgot about the downside of the Calva Doctrine, and they forgot about how bad espousal was as a way to address any of these things. State espousal is terrible. It's politicized. It's a distraction for governments. There's all kinds of problems. So the whole investment treaty movement arose out of some really conditions that needed to be fixed. There was some genius applied, particularly in the creation of the ICSID convention, about a method to do this, drawing on commercial arbitration, but creating essentially equality in that arbitration process between the investor and the state. It's really, small L liberal rules executed extremely well. And our elected officials completely forgot about this. They were bamboozled when the criticisms began. So U.S. policy has been through a long train since the mid 90s and the failure of the MAI. I mean, at that point in time in the United States, if you ask somebody what an investment treaty was and whether they should care about it, unless you talk to somebody in the State Department, nobody probably knew. No elected official could answer that question. It just was sort of a lawyer's issue and very much dormant. Then came NAFTA, and importantly, then came MONDIF and ADF and cases where the United States was a respondent. And that changed the point of view and caused a real reappraisal, both within the executive branch, who had to now defend these cases. Sometimes they were pretty ugly. I mean, MONDEF was a state case, and the federal government wound up defending it, as they always do. But also politicians got curious about it. And so this led to the big debates in the 2001 and 2002 period, which led to the Trade Priorities Act of 2002, where Congress stipulated that foreigners should have no greater substantive rights than American investors in America. Now, that constrained investment policy in important ways and led to a process that resulted in the 2004 model BIT. It's when the U.S. model bilateral investment treaty went from an 8-page document nobody paid attention to a 40-page document that everybody had a hand in. But at the same time, we still had a document. There was still a model. The model did a fairly reliable job of taking U.S. law and practice and conforming it to the principles that were operative in the international arbitration process. So that seemed to work. We went a step further in the Dominican Republic Central America Free Trade Agreement. Senator Baucus insisted that the implementing bill included an appellate mechanism or equivalent for investment procedures in DR-CAFTA. So we've toyed with the appellate mechanism as well. All some reforms. Now, the Obama administration came in office in 2009. A lot of their supporters were some of the critics of ISDS, so they started another review. And much to the credit of the Obama administration, the 2012 model BIT, the product of that review, was very similar to the 2004, and the administration defended it all the way through 2015, the debate over Trade Promotion Authority, where there was a Senate amendment, the Warren Amendment. Senator Warren of Massachusetts made an amendment to strip investor state dispute settlement from U.S. Investment policy objectives. That amendment was defeated 60 to 39, and with all Republicans voting no and 9 Democrats voting no. So it was pretty good bipartisan support. So what you have in the United States, at least for ISDS, the situation is probably better than its press clippings. Okay, now we'll move, and I'll stop with the current position, which I think is what we ought to talk about because it confuses me. Frankly, I would side with many of the commentators today who consider our president's statements on trade to be somewhat incoherent. I do think that Ambassador Lighthizer and Secretary Ross have an agenda. Okay, these are very results-oriented people, and their agenda is very simple. Overall, they want to use the tools of U.S. trade and investment policy to incentivize U.S. production and operations. That's what they're about. That's what all the decisions focus on. And they don't really care if it violates the nuts and bolts of trade rules. You can see that. All right, we talked about rules of origin for autos. They're really not concerned about the industry's statements about global competitiveness. They want more production in the United States. Look at the Korea-U.S. Free Trade Agreement modifications. There's a quantitative arrangement on steel, a 70% quota. All right. Last I checked, in GATT 94, we promised not to use quantitative measures. Big deal. We're using them. Okay? And likewise, when it comes to the rule of law and sort of the liberal order, doesn't really matter. Let's make investment riskier outside the United States if it achieves our objective, which is to incentivize the production and operations in the United States. So now the Ambassador Lighthizer went so far as to call Chapter 11 a government-subsidized risk insurance for outsourcing. And this week's Wall Street Journal editorial page criticized him for that statement and pointed out that you could also characterize trade remedy law in a similar way to what he's been practicing for 30 years. But that aside, Congress, Congress has spoken recently. I believe they will defend the need for and the prominence of investor-state dispute settlement in U.S. investment agreements. But there's a missing element in U.S. policy right at the moment, and that missing element is support for sort of the liberal rules-based order. For me, the real risk is we have a group of advocates who want results. They want to, and if they have to advocate for illiberal policy to get those results, that's really okay with them. In which case, power becomes superior to rules, and I think we'll all miss it when it's gone. But we risk the chance of losing it. So I'll stop there. Thank you.
Power taking over from rules. Oh, is that good for business? Over to you, Selma.
I don't know, when we talk about power taking over from rules, I heard this morning politics overcomes economic, security trumps politics. So where does that leave us in the bigger picture? I've been coming to this thanks to my good friend Michael Robinson since 1985. I've not always been here every year. And our title this year is a very interesting one where it's Back to the Future. And I can think back to the time when we had the Canada-US Free Trade Agreement and we were debating similar issues. And then we had the Nafta on the books or under negotiation. And it seems that we're going around in a circle. And while not specifically on topic, one of my concerns is there's such a lot of protectionist rhetoric around. And the Institute, I think, has an important role or potential to play to actually put out some thought-provoking pieces about how important free trade is. So I come at this conference as a free trader, obviously private sector. While I studied international law and wrote extensively on trade law remedies early in my career, I don't do that on a day-to-day basis. So it's somewhat daunting to be in the room with the likes of some of the individuals that have been coming to this conference for the last 30 plus years who are truly experts. So I will offer my views more from a pragmatic and from a business perspective. And number one would be is that business likes certainty. Business likes predictability. So as much as I heard the discussions around Chapter 11 earlier today, I found it quite distressing that the reason we don't want Chapter 11 for Mexico is that it destabilizes the environment in which business can invest in a country. I find that very, very regressive and very concerning as a free trader. And I was very heartened, because I've known Dan for a very long time, when he stepped in at some point to clarify that these were not his points of views or those of DLA Piper, because I have to say I really thought Dan had gone south and drunk the Kool-Aid as someone who used to hang out and supported the Canadian government. So I'll make a few comments about Chapter 19, and then I also want to talk a little bit about some of the other dispute settlement, and then particularly the initiatives of the NAFTA 2022 committee. I was interested to hear that Scott said that due to the quiet period between 2012 and 2016, we missed an opportunity in the area of trade remedy law. So I would like to take us back and remember that when we entered into the NAFTA in the early 1990s, we did not have the WTO agreement that we have today. We did not have the dispute settlement process that exists today under the WTO. I've learned a lot and heard a lot today about the shortcomings of that process, or is it not as much the process as to how it's being applied today, and that we're not necessarily satisfied with the quality or the caliber of the decisions that are being made, but those are things that could certainly be remedied. The concept that there's something wrong with forum shopping is an interesting one, because as lawyers, we're always forum shopping. We're always looking to see where we can get the best judgment for our clients, whether that is a particular local judge, whether it is through arbitration. And I don't know that we'd have countries signing trade agreements if they had to go to the lowest common denominator. So there were benefits, and there was a decision made when we entered first into the Canada-US Free Trade Agreement and then into the NAFTA that this would be an economic region, it would be an economic powerhouse, and as some commented in the last panel, that there would be, would provide North America, including Mexico, with a competitive advantage on the international stage of trade. And I'd be very concerned if we lost sight of that. And therefore to say that, well, you have to choose between, it's not the right thing to choose between going under the NAFTA or going under the WTO, that's very counterintuitive, because you always want to go where you get the best result. Ideally, you have the same caliber of decision-making within, I'll say, the NAFTA dispute resolution processes as you would under the WTO, but that's not necessarily the case given how those structures exist. I went and did a little bit of reading about, and this comes back to your comment, Scott, about the quiet period, about the number of disputes that have been under Chapter 19. And I think that since the NAFTA started, there have been I think over 70 cases under Chapter 19. 47 of those cases were against the United States. 36 of those were decided unanimously, so a binational panel making a unanimous decision. So in my view, that's over 80%. It doesn't support a view, which I'm hearing in certainly the political rhetoric, that the U.S. is being unfairly treated in front of binational panels. The U.S. has input into who sits on those binational panels, and perhaps it needs to identify other individuals to serve on those panels if it's not satisfied with the outcome. But I think the reality is people have their professional reputations at stake, and notwithstanding political pressure, at the end of the day, people want to maintain their own personal integrity when they're serving on these panels and not be accused of bias. So when you say that it was a missed opportunity, I would say perhaps the lack of cases over the last 5 years under Chapter 19 shows that it's actually working because it has a deterring effect on those that are making decisions, whether it's the ITC or the CITT or the Mexican equivalent, to make decisions because they know that there's an opportunity for that decision to be reviewed by a binational panel and to be criticized for the decisions that they make. And someone earlier today made the very insightful comment, I thought, or at least good observation, is one of the reasons these panels have become or were attractive, particularly in the early 1990s, was that Canada had a very strong view, and so did Mexico, that it was the mouse and the elephant, and that we were being disadvantaged in front of the ITC in the United States, and that therefore that justice was not being served or trade remedy law was not being applied fairly and equally. And so with the passage of time, now that we have 30 years behind us, we see that there are far less of those cases. So I just throw it out there. Does that mean that, in fact, we do think that trade remedy law is being applied more fairly today than it was 30 years ago? Coming from the aviation industry most recently, the Boeing case would suggest that, the ITC did a great job in terms of what was clearly anti-competitive, if not unfair, imposition. So those are sort of my comments on Chapter 19. Now, it's something we don't talk about a lot, and I guess the other question I have about Chapter 19, we've talked about renovating the Nafta. Is throwing out Chapter 19 really a renovation? And I loved, Dan, again, had a very cute way of describing, the renovating the house, but throwing out Chapter 19 is not necessarily a renovation. That's actually just deleting something or destroying something that exists. So my question to the audience would be, if we have time, is how would you change NAFTA's Chapter 19? How could it be better if it's really perceived not to be working today? One of the things we haven't heard a lot about, but the topic of this panel, of course, is dispute resolution under the NAFTA, and that is the very successful innovation, I think, under the NAFTA of establishing the Fruit and Vegetable Dispute Resolution Corporation. And that was under Article 707 of the NAFTA. There was an identification at the time of the negotiation of the NAFTA that one of the disputes between both Mexico and the United States, Mexico and Canada, US, Canada, all countries, well, however you pair them, was in fact about produce that was crossing the border and the need for a very quick and effective dispute resolution process so that goods could actually cross the border in a timely manner. So one of the initiatives that the food industry undertook with the institutional support of all three governments was to set up this Fruit and Vegetable Dispute Resolution Corporation, which engages in binding arbitration with respect to the quality, quantity of produce that cross the border when there is a dispute. So I think that that's a highlight that we should not ignore. Then when we look at Chapter 20, it has not been used very frequently, and it's a very good question to ask why. And perhaps, again, I could play devil's advocate and say just the mere existence of Chapter 20 may, in and of itself, provide a disincentive for bad decision making. I appreciate that's a bit of a rose-colored glasses view, but you have to ask yourself that question, and specifically agricultural and phytosanitary, government procurement, and financial services are referred to under Chapter 20 for special consideration where a party believes that there has been, for lack of a better word, I'll say a miscarriage of or misapplication of domestic law. And I think that kind of check and balance if you continue to subscribe to the importance of having a North American trading region, then it's very important to have that opportunity. So I'd now like to talk a little bit about NAFTA 2022. So there is a bit of a juxtaposition. So far today we've really talked about what I would characterize public international law, and this is really a private international law initiative, and it is quite unique. It's one of the very few private international law provisions in the NAFTA. And that section, I'm not going to read it to you, but it starts out with framing, and I guess that shows you a little bit of my psyche in earlier comments, that the promotion of trade is what underpins the NAFTA. And in order for trade to succeed in the NAFTA region or in any economic relationship, there has to be confidence in the dispute settlement process that's available to businesses that invest in a foreign country. And so with that in mind, the three governments established this working committee. It's called the Chapter 2022 Committee on the Private Resolution of Commercial Disputes, or some other very lengthy title. It's comprised of 10 individuals from Canada, the United States, and Mexico each. So it's a working group of 30. There are government co-chairs. When this first started, there was a tremendous amount of concern, particularly within the American delegation, about highly confidential information being shared, in-camera rules or whatever, and it quickly became evident that there was no need for that, because really the focus of this committee was first to do an assessment of what the status was of alternative dispute resolution in the NAFTA region, and whether there were barriers to the enforcement of ADR or alternative arbitral awards. And then what the focus was as well to determine whether or not there were specific sectors which would benefit from ADR versus others. And that's still a work in progress under the committee, but one group that we worked very closely with was the 707 group under the Fruit and Vegetable Dispute Resolution Corporation. The committee meets typically once a year, although since inception we've probably met over 30 times. We are very politically correct. We rotate between the three countries. Within each country we rotate where we meet. It's the quintessential NAFTA solution, and certainly a very Canadian one, where we can never have a meeting twice in the same city within a decade, which is not without its challenges.
How was Regina? Yeah,
Oh, yeah,
just
no,
kidding.
we haven't made it to Regina. Oh, you know what? We've got two mics on. That's probably the cause. There was also an initial focus on cooperation between arbitral institutions or alternative dispute resolution institutions. And that has sort of faded away, because one of the changes that's taken place over the last 30 years is that ADR has really come into its own. And again, when you think about it, and I'll just give the Bay Street example, where today there must be 20, if not 40, law firms or boutiques that specialize in alternative dispute resolution. That wasn't the case when this started, and the awareness of ADR was much lower. ADR was not resorted to as frequently as it is today. It's now a very common provision in private commercial agreements to provide a multi-stepped dispute resolution clause to go from frequently executive consultation to mediation and then to binding arbitration, and with an ability to appeal if there has been a misapplication of the law. This group that I've been lucky enough to work with over the last number of years has engaged in a number of initiatives. There is a website that you can find. If you plug in NAFTA 2022, the website will pop up. It has sample arbitration clauses. It has sample arbitration agreements that have been vetted by all three countries. We've made a number of discoveries very early on in the work that we were doing. One was that arbitration was particularly important for small and medium-sized enterprises. It will not be a surprise to hear that what the U.S. thought were small and medium-sized enterprises was very different from what the Canadians and the Mexicans thought were small and medium-sized enterprises. We are very much focused on businesses that were looking to expand their business opportunities and did not necessarily have in-house counsel or even have external counsel that they would use. So how do you help these people, and how do you promote trade? How do you convince investors that if they have a dispute in a foreign jurisdiction, that they will be able to get justice? And I'm not telling tales out of school. I think there was a fair distrust amongst different members of the business community, both with the Mexican judicial system and also with certain parts of, we would call it the litigation-happy American judicial system. Since that time, we've had the privilege of class action lawsuits moving north of the border, so perhaps we too now could be put in the same bucket. But again, going back to when we set up the NAFTA, these were all issues when you go back to the underlying intention of those that entered into this agreement was to promote and facilitate trade between our respective countries and to give our businesses a competitive advantage, not only within North America, but also on the world stage. More recently, we have been looking at and have recommended that the mandate of this committee were to continue under a new NAFTA be expanded to include mediation, to look at treaties that enforce mediation, which are few and far between. One of the first pieces of work was to determine whether arbitral awards could be enforced between the three countries, and the short answer is yes, so that was not a problem. But mediation is an area that's becoming increasingly popular, and if you have a binding mediation agreement as opposed to an arbitral award, can you go out and enforce that in a foreign jurisdiction? And would it have the same as if a judgment issued by a court, which is the case when you have an arbitral award? We have also more recently looked at specific sectors in the context of whether or not there should be unique dispute settlement provisions within different sectors of the economy. Trucking is one where we have done significant work, and we've been surveying the industry. So far, the information we have is inconclusive. We looked at oil and gas. We looked at natural resources. One of the other areas that's being looked at now currently is online dispute resolution within the NAFTA region. And again, it's very much focused on small and medium-sized businesses who don't want to go to court, who don't want to have an arbitral procedure. I think many lawyers today would agree that arbitration is not necessarily cheaper and it's not necessarily faster than the court system, although the latter is more within your control depending on how you draft your arbitral clause. We have always had a judicial subcommittee, and part of the work of the judicial subcommittee is to look at recent arbitration decisions, court decisions where arbitration has come up. And one of the conclusions we came to about, I would say, a good 15 years ago was that the understanding within the judiciary with respect to the enforcement of arbitral awards was not of the same quality at the national and state level in the United States, and definitely not within Mexico, and also not within Canada. So we have done significant work reaching out to the judiciary and have had training programs put into the judicial training programs that are run by states or federal governments, depending on the jurisdiction, to ensure that there is a greater awareness of the basis upon which an arbitral award can be appealed, the need to enforce an arbitral award as if it was a judgment of a local court. That is still a work in progress. Our next meeting will be in Mexico City in June, and I believe part of that program would be to do another session, a joint session with the judiciary in Mexico City. We've done some very innovative things. We have brought in people from industry groups to come and talk to us about the challenges that they have encountered in the different NAFTA jurisdictions. We've also reached out to Native and Aboriginal groups to look at alternative dispute resolution processes. particularly when you start looking at natural resource development, which is huge both in Canada and in Mexico. As I said, we have a website that has a lot of the material on there. The composition of the committee has changed from time to time. We've had people leave the committee, come back. It's all by government appointment. So if I were to look at this in the future, one of the things I would say is that what is needed, and certainly the governments that participated in the Nafta have said that when they're negotiating new free trade agreements, this came up in the Free Trade Agreement of the Americas, this came up in the Canada, Central America Free Trade Agreement, and a number of others, they would put similar provisions in there. The challenge for those that sit on the committee is there's almost no government infrastructure to support the work of the committee. People do this on an unpaid basis. It's a volunteer community service type initiative. So it's often hard to move the yardstick forward between meetings. And I would say for a very small amount of money, the work of this type of a committee could have far greater benefit in terms of supporting the promotion of trade within the NAFTA region. So I'll leave it at that. Thank you.
So we have a great deal for potential discussion, questions, comments, and solutions. Before I actually start to deal with audience reaction, I just want to expand as well, because we did mention during the day that there may be a discussion of dispute settlement through the WTO, also a potential topic for discussion. And let us not forget dispute settlement under the side agreements in NAFTA, or possibly, I guess, maybe chapters in a revised NAFTA. There are two side agreements to NAFTA, one on the environment, which has been active, and the other one on labor, which has not been terribly active, but we may see discussion about what would be in a labor chapter. So many things to talk about and resolve. I'll start off with Larry Herman.
I thought that was a very interesting presentation. Let me try and address some of the issues and ask some questions. We've covered a lot of ground. I'm going to put a proposition, and I'll ask Scott Miller to answer it. I don't see any need for ISDS between Canada and the United States. I mean, as a real practical issue, we can take that out of the NAFTA if that's necessary for purposes of the negotiations. And there's a lot of reasons for that, but you have to go back to the basics of ISDS. ISDS, or BITs, or FIPAs as we call them, were developed 30 years ago to try and get capital flows into the developing world.
Yes, that's right.
Yeah.
Mm-hmm.
It is not appropriate in a Canada-US context. If you look at the genesis of investor-state treaties, it's not necessary in the Canada-US context. You can, however, within Chapter 11, you can maintain Chapter 11 and maintain the obligations for non-discriminatory treatment for investors. You can maintain that as a state-to-state obligation. You don't need ISDS in my view. That's a proposition. I'd like to hear your comments on that. On Chapter 19, there's a lot of myths about the binational panel review system. It is forgotten that in the original free trade agreement between Canada and the United States, the binational panel system had a fixed life of 7 years. It was to end after 5 years with the possibility of 2 years renewal, and it was then replicated in the NAFTA and given permanent life in that treaty. But originally, Canada was prepared to agree to a 7-year sunset for Chapter 19. So we have to keep that in mind. It seems to me, and I'd like your reaction to this, it seems to me that if as a matter of political negotiation, one had to give up Chapter 19. You could rejig Chapter 20. You could rejig Chapter 20 to provide, on a state-to-state basis, for enhanced jurisdiction of the panels and enforcement provisions to ensure that the Mexican trucking situation didn't occur. You could do that.
Yeah.
It's not beyond the ingenuity of lawyers to develop a proper state-to-state system. Now, you've talked about the risks of state espousal, and that is true. But in a Canada-US context, let's look at the record. All of the, if you like, the Chapter 19 cases have involved major issues of national importance for Canada. So it's not like a small sector was affected by a trade dispute. These are usually large cases where, in my view, state espousal may make some sense. So it becomes a Canada-US state-to-state dispute, for example, where Canada says the U.S. did not live up to its Nafta obligations in this particular investigation.
Yes. Okay.
You could do that, and that would be, but it would have to be done very, very well, and in order to give up Chapter 19, Canada, I think, would have to show that there were major gains under Chapter 20. So, those are some thoughts. I'd like your comments.
Sure, thank you. Let me take first the question about the applicability of an investment agreement and investor state between the U.S. and Canada. When you first suggested that, I said you probably ought to talk to the people at SD Myers before you come to conclusions. But that's unfair, because our legal systems are very similar. They're highly developed, and you're absolutely correct that the original intent, starting with the Germany-Pakistan bid of 1959, was to first, it was a development objective to get capital into developing countries, and second, the need for a neutral arbitration forum had to do with the development of law in the developing countries and your ability to get a fair shake. So that's definitely the case. I can tell you the United States has experimented with that. If you look at the U.S.-Australia Free Trade Agreement, the U.S.-Australia Free Trade Agreement has a chapter on investment with the same substantive obligations, but without ISDS. Because at the moment that agreement was being negotiated, the ISDS process objections had reached a screech in Australia, and the Australian government just couldn't handle it, particularly not with the litigious United States. Okay, which I understand that was bad politics, that they had to deal with. And it was basically one of the last concessions. We agreed to state-to-state dispute settlement on investment if they agreed not to bug us on sugar. And so, in a magnanimous American fashion, we continue to protect our sugar industry and ensure the Faneuil brothers' continued prosperity in exchange for that. But what I would tell you, two things. One is, it didn't really affect U.S.-Australia investment at all, because, like Canada, Australia is a common law jurisdiction with high-quality courts and basic procedural fairness, and foreigners get a fair shake in Australian courts as they do in Canadian courts. The second thing is that when it came time to negotiate the Trans-Pacific Partnership, many years later, Australia had no objections to undertaking ISDS as part of the TPP investment chapter, even knowing that it would expose them to cases from U.S. investors. So the politics changed, and I'd be interested in hearing, actually, I think your question would be best answered by the Australians, who had what you wanted for Canada, and then in TPP accepted something else. And I think it may have just been the complexity. It's hard to say what happened. But I do agree with your point. I do think that if it were an essential to sort of as a way to proceed, if it was a classic barrier, then as it was in Australia, it was a tough issue that needed final resolution at very high levels, that it would be entirely possible. Chapter 20, I actually like that solution. Now, look, I'm an old soap salesman. I don't have a lot of history with the anti-dumping laws, and to know about how Chapter 19 got there and why it's important. I do agree with you that it was a Canada a pain for Canada that needed to be addressed, and it needed to be addressed at very high levels. That's how it got there in the first place. If that pain is still there, then it ought to be considered in the context of the negotiation. I do admire the cleverness you're suggesting in the drafting, that basically essentially make trade remedy cases subject to state-to-state dispute settlement, which is a deft way to consolidate the two chapters. Whether anybody would accept that, I can't tell you, but I admire the creativity.
John Johnson, I'm moving from right to left. I'm not sure if that's how I should characterize this politically. My right to my left.
Yeah, it's John Johnson. You know, the biggest problem I have with Chapter 19 is practical in that it requires a great deal of cooperation on the part of the U.S. side to work. And for the first 10 years, we had effective cooperation on the U.S. side, and actually it worked very well. And then we hit Lumber 4. And essentially, you had the agencies in the U.S., the Department of Commerce. I think there was 5 remands back to the Department of Commerce, and so on and so on. And the ITC was similar. The administration then did an end run with Section 129(1)(c) of the Uruguay-Iran Agreements Act, which enabled the ITC to come up with a fresh injury finding. Thanks to Mark Moran, by the way, your partner, that went to court, and the U.S. lost, but it was moot by that time. And then the U.S. wouldn't give the money back, and we won that case as well. It was ultimately resolved in a wheat case. I think the killer with Chapter 19 is the constitutionality, though, has never been resolved in U.S. law.
Right.
I am assured by U.S. counsel I highly respect that they don't have a case. On the other hand, the only way that can ever be determined is for it to go the full route.
Right.
And the problem in the context of a dumping countervail case where you've got these huge duties being collected is that we'll cave. So I guess Chapter 19 was creative. It addressed a problem at the time. I think it would work if we did have cooperation, if we didn't have this constitutional problem hanging out there.
Yes.
But it is. Anyway, that's...
No, I think you're right. And in my view, just practically, I don't think there is a treaty mechanism that's been conceived by the mind of man that could fix softwood lumber. Right? That's a 100-plus-year-old argument that is so deeply rooted and so passionate.
This question from Mr. Lissenberg. With regards to Quebec having a civil law tradition and not a common law, how do American private companies approach this? Do you ever see any hesitation on your side? You say Canada, we have a common law tradition, except for in Quebec when it comes to disputes between private entities. So I'm wondering, does it come up in your meetings? Do anyone address it? Has it been a source of any challenges for U.S. companies?
Well, it's probably, I'm trying to think of how long I've not been in private practice. It's been a long time, since sometime in the early 1990s. I'm not aware of it being an issue. I would almost defer to Michael or Larry from a law firm perspective. I'm not aware of it. I mean, you can carry on business in Quebec and incorporate in Ontario or incorporate federally. It is a different legal system. I'm not aware of it being a deterrent to people investing. This is probably a politically incorrect statement to make, but a far greater deterrence to investment in Quebec are the French language laws, where the language in the workplace has to be French, and employers find creative ways around that, particularly given that Quebec has provided substantial grants and incentives in the high tech and in the pharmaceutical industry, and yet many of the people that are brought in to work in that sector, neither English nor French is their first language. And I've recently heard a story from a highly, highly successful company CEO, and she was telling me that what they do when the French language office comes and checks, they send a note out the day before and suggest that people work from home. And therefore, you only have the people whose mother tongue is French or who are fluently bilingual in the office. That is a significant issue and disincentive for companies to locate in the province of Quebec, far less so than the civil law system, because civil law system operates throughout, throughout Europe very successfully, and we don't hear that that's a drawback to success. And we don't have any of the. I'm not necessarily saying that they're wrong, but it's a very different governance model. We don't have the administrative councils and the labor councils that you see in Europe, which is a different layer. But again, companies worldwide manage within those frameworks, so I don't really see it as an issue. It's the French language is the far bigger issue.
Thank you. I'm going to move in this direction next, and I should have been asking people to identify themselves for the record as you speak.
My name is Ananya Molavarpu, and I'm a third-year law student here, which probably explains my question. Earlier, Ms. Lusenberg, you mentioned that certain judiciaries don't like to implement or have difficulty implementing some of the arbitral awards. So I was just wondering if you could clarify your comment. Why do they do that, or is there particular sections of the awards, and where is this exactly?
Sure. International commercial arbitration has come into its own in the last 25 years. After we did the initial work within the Nafta 2022, we turned our mind to other barriers, almost like are there other non-tariff barriers to enforcing arbitral awards. And it became clear not that people were unwilling, they were unfamiliar, their training, their education, there was a reluctance, there was a lack of understanding of the basis upon which you can appeal a final arbitral award. Which is a miscarriage of natural justice or an error of law, and so and a reluctance to enforce certain awards just because they hadn't seen it before. And again, remember that was at the beginning of, the NAFTA is only 30 odd years old, and so with the passage of time and increased foreign investment, particularly in Mexico, but both in Canada and the United States as well, and an increased number of disputes, because that's the reality, is that you don't always, not every business relationship works out as you would like, and some very, very positive business relationships have gone to arbitration and have continued, and it's been the best way to take the heat off the day-to-day operations, to take it away from the plant manager or from the distributor or whomever and move it to an independent third party so that business can continue, because I'm not making fun of this, but often it's only a matter of money and how much money has to be paid to whom and what was the quantity of the damages that were suffered, which is quite different from, we'll call it expropriation, an investor host, right? That's a very different issue when your whole business is being undermined.
I think the next question was Todd Weiler.
Well, as counsel to S.D. Myers,
Thanks for the shout out.
just want to thank for the show. Yeah, I'm sorry, Larry, but I disagree. I just think that the companies, Bill Kahn, Windstream, Abitibi, Bowater, S.D. Myers, and Pope and Talbot might also disagree, given that those are 5 awards that have been rendered against Canada for breaching its NAFTA obligations. My only question, I suppose, was with regard to your agreement or seeming agreement with Larry, is with regard to the treatment no less favorable provision. Why would we want to get rid of that? I mean, I can understand how one might say, well, fair and equitable treatment can be covered by the local courts, but that can't take care of non-discrimination provisions.
Yeah, right.
So it seems to me we'd still need those. And of course, again, Abitibi Bowater might say we might want to have an expropriation compensation provision in there too. So what do you think about expropriation?
Well, look, I'm not in favor of it. Okay, I'm not in favor of expropriation without compensation. And due process and public use, public purpose. But in any case, no. Look, I think that on a practical level, I think that you wind up pretty quickly, as even the United States winds up being willing to accept the obligations of an arbitration clause of investor state, because it wants the ability to do that in the foreign market. In the NAFTA, I would think carving out Canada and not Mexico would be a neat trick. Now, that's not to say anything unfavorable about Canadian law and Canadian jurisdiction. And look, these cases are hard. They're sometimes decided very closely. I would note that the U.S. pharmaceutical industry, when it came to the promise utility doctrine, did a lot better in Canadian courts than they did in a Chapter 11 case. Okay, so this stuff doesn't always, you can't really get as results oriented as you'd like to with this. But I do think that the reason the United States has obligated itself to submit to arbitration, despite success, despite our Article 3 courts being pretty darn fair in terms of their treatment of foreign entities, and the fact that at the International Court of Claims, complainants win all the time against the United States. Having a good legal system is not an adequate reason to exclude this. And I think that the principle involved here is that capital exporters and more importantly, economies with high quality legal systems ought to embrace the notion that if there's a dispute settlement procedure on the side, if you've got this commercial arbitration procedure, it doesn't really interfere with who we are as an economy. It doesn't say anything about our legal system, but making it available protects our investors abroad, and it advances the small L liberal order. So I was basically exploring the question of would it be politically possible, but substantively, actually, I think the United States has always accepted these obligations, even the cases that are really messy. I mean, Glennis Gold was some Mickey Mouse regulation by the state of California, and the Office of Legal Counsel did a heroic job. Okay, sometimes we go overboard, and for instance, I think that the right thing to do with the Lowen case would have been to settle it, and then for the feds to go after the state of Mississippi for that little version of Mississippi justice. Okay, but we were trying to win, and we managed to bankrupt the Lowen company in order to win. So you can go too far in almost any of these, but as a practical matter, look, I'm a fan of the Canadian legal system. I ran one of Procter & Gamble's businesses in Canada for 3 years. I'm familiar enough with it to know it is reliable. At the same time, if you want to be a capital exporter economy and you want to promote the values that are inherent in the liberal order, then accepting, access to dispute settlement seems a small price.
I'm going to go in order in which I saw the dispute, or saw the questions. There's a question there. I think I saw Michael Robinson first, and then I will move that way. So, Michael first.
Kai's been given the mic.
Oh, Kai has the mic. Okay, I've been overruled by higher authority, and I will defer to the organizers. Yes, Kai, please proceed.
Thank you. So my question is to the panel, and perhaps one of you would like to comment on this rather than the others, but one of the things that's sort of coursed at ebbed and flowed today has been this constitutional crisis that's been going on and brewing in the appellate body of the WTO. Over U.S. blockage of appointments to the appellate body. This is a situation that takes great, takes center stage right now given the attitude of the U.S. administration. But it's actually something that goes back quite some time. And I'm curious why successive administrations have allowed the situation to fester like this. Is this a sort of, in your view, a sort of deliberate attempt to kneecap the WTO? Or is this just something that somebody forgot about and has now taken on this very, very serious face, if you will?
Well, I can talk about what I think is going on in the U.S. politics. You're right, this has been a long time coming. And as international institutions go, the WTO would rank highly on the list of the least bad. Okay? It actually, I mean, there's some things it hasn't done in a while, like come up with an agreement on much of anything. But the WTO in general and the dispute settlement understanding in particular is functioning not terribly. And when you're president of the United States or running any executive agency in the United States, you got a lot of problems. All right, and so this one I don't think arose to the top of the list for anybody. Look, my experience. This goes back to I had to explain to members of Congress why we had to change our tax law because of the Fisk ETI, and what the explanation came down to, I'm sorry to say, is we got our footnote, we didn't get our footnote, and the Europeans got theirs. And somebody decided we had to change. And it's a really unsatisfactory explanation for any politician. And I got chased out of some offices trying to make that explanation. So it, you know, it goes back at least that far. But there's also there's the United States has, because the WTO dispute settlement understanding has provided some overall benefits, it didn't want to act to undermine it. They often sort of look the other way on some of these issues. So I think it was a matter of priority calls. What we have now is an administration that is by its campaign promises disruptive. Okay, and you have a trade representative as essentially a 30-year practitioner in trade law who has some very clear views on this and has the president's ear. And so I think that's what has caused it to arise. I think the other compounding factor is it was, I guess, about a month ago we finally swore in our Geneva ambassador. Okay, and so there's been a lot of this that's been handled long distance, which I think probably made it more difficult and sort of escalated the tensions. So it's a variety of factors. But I think, you know, if President of the United States have a lot of problems, okay, and this was an irritant, and a lot of trade lawyers and practitioners in the United States were concerned about the direction that appellate body in particular was going. But I think they had other problems to raise, and we're just raising them now. I don't have a better answer. I'm sorry.
Now, Michael.
Thank you. Just a short comment in response to the question about civil law of Quebec and how it might be factored in. I think it's always important to remember, as I used to tell classes when I taught at Western on Nafta, that both Section 102 sub 2 and 1131.1 say the applicable law is international law. So the issue isn't going to arise unless there's something in international law that says one must have some sort of deference to civil law in that connection. I don't think it'll arise. And of course, the other chapter that does have national law is Chapter 19, of course, because it just goes back to the particular jurisdiction. Mm-hmm. And I would make one comment. I would agree with Larry, and I'm not sure what the concern is of Todd's. That if we had to get some concession on Chapter 11 to get this darn agreement otherwise quite acceptable through, then we could move Chapter 11 into Chapter 20, the dispute settlement portion. Of course, we can't move the performance, the prohibition against the performance requirements in, or the whole thing would collapse. Yes, but I'd be interested in Todd's reaction to that. I probably
well, first, just a point in terms of U.S. politics, that would be a step backwards, given the statements of the chairman of the Ways and Means Committee and the chairman of the Senate Finance Committee, who are both defending ISDS and saying it's an essential element. Now, the Canadian politics are maybe and probably are different. So it's an interesting thought experiment for a trade-off, but it's not necessarily one where there's a lot of agreement.
We always lose. That's why.
Yeah, I understand. Yeah, understood. Okay.
Further resolutions, comments, suggestions. I get the sense that we haven't solved everything. We've just kind of stopped. And as I said at the beginning, sometimes that can be a very good thing. We've been through a whole lot of thinking and all kinds of discussions today. So if we don't have solutions today, maybe we have them tomorrow, right? Signing off as Pollyanna, perhaps.
Just one thing that I wanted to pick up on, a comment about this quiet period in anti-dumping. Yes. There is actually a commercial reason underlying that. And if you look just very practically, look at it. About 2/3 of the cases of both anti-dumping and countervailing duty cases in both the U.S. and Canada are in steel and chemicals. Okay, and because of NAFTA, the North American steel industry and the North American chemical industry are highly integrated. What a surprise after 20 years. And so what you have, particularly in the steel cases, where you have the same labor union, the same ownership of a lot of the mills, the same products, you also have the same cases being filed against the same importers on the same classes of products. So it was one of the reasons that things got quiet on anti-dumping is a very sound commercial reason called commercial integration, which is exactly what we were trying for in the U.S.-Canada Free Trade Agreement and the Nafta. It's probably still a lost opportunity, but NAFTA did something, and that's at least one of the reasons that we're not fighting about these things other than lumber as much.
With that, I'd like to thank the panelists and members of the audience for a very interesting discussion.
Well, thank you all for yet another great discussion. At this point, all of our substantive discussions are pretty much finished. We have Kai Carmody, our Canadian National Director, who at this point will close us out. And I know it's Friday afternoon, so instead of taking a break and doing that, I thought might as well just do that right now. So, Kai.
So for those of you I haven't met, my name is Kai Carmody. As announced, I'm the Canadian National Director of the Canidius Law Institute. I teach at the University of Western Ontario Faculty of Law. And I've attended these annual conferences since 2000. And the title suggested that this conference in particular was going to be one of the more interesting ones that we were invited to attend and hear about. The theme of this year's conference, Back to the Future, the Canada-United States relationship at the Crossroads, riffs on a 1985 adventure film that many of you may be familiar with, Back to the Future, directed by Robert Zemeckis and starring the Canadian actor Michael J. Fox. And in that film, as many of you will remember, it happens to be one of my personal favorites, Fox played the teenager Marty McFly, who is sent back in time from 1985 to 1955. And it's there that he meets his future parents, and he becomes, oddly and edipally, his mother's own love interest. And an eccentric scientist, Doc Brown, inventor of a time-traveling DeLorean car, helps Marty to repair history and return to 1985. And I think Zemeckis' film has become a classic in part because it metaphorically captures the way in which we, at this time, are in something of an uncharted time, and more broadly, the sort of contrapuntal impulses in our current political landscape. Back to the Future is shorthand, I think, for a universal human longing to return to a sort of idyllic past that was problem-free. The problem is that the past had its problems. I think as we were profiled in the last panel, and as Scott Miller reminded us, in reference to espousal in international investment law, there were a lot of problems before we had NAFTA, before we had the WTO agreement. Problems that I think it's easy to forget about in an era that has become squeak-free, if you will. In Zemeckis' telling of the tale, McFly finds out about these problems by going back to fictional Hill Valley, California, where he sees the beginnings of his family, and there are all sorts of madcap adventures that the film is famous for. But if you look closely at that film, and I've watched it a few times, you'll see that through Marty's eyes, what he sees is the stifling conformity of the 1950s. He sees the racial discrimination of that era. And he also sees the suspicion of a lot of new things, pointed out most prominently and evidently in the down-filled vest that he wears, which is referred to by a series of bullies as a life preserver. Why are you wearing that life preserver, kid? He's asked that on a number of occasions. And I think we've seen that same idea, that same concern with novelty Back to the Future, being expressed and having a powerful resonance in the current political landscape. We have powers in place at what appears to be their apogee, whose political base would like to go back to the future. Why? Because the perception is that things in the past used to be a lot better. No one can ignore the words that were spoken at this very conference last year by the Washington trade lawyer Terrence Stewart, and echoed this year by Jim Blanchard, who noted that there has for 40 years been essentially stagnant income in a considerable portion of the US population. And so for people like that, the past was rosier. Kind of like Marty McFly might have imagined prior to his particular time trip. And what also struck me from a look at last year's conference proceedings was an observation made by former US Ambassador to Canada, Bruce Heyman, about the fact that what we should expect going forward is an administration that will not assume an entirely rational approach to trade negotiations. The administration will pursue, as he said, an asymmetrical trade strategy, and what we're seeing is exactly that. What we're seeing is perhaps the high water mark of such asymmetry. As Minister McKay said last night, the daily uncertainty of life today is a killer. Consul General George pointed out this morning how business in Indiana and elsewhere is now very worried about the possibility of and the actuality of retaliation by China. Canada may land in the crosshairs of that. Businesses need certainty, they need stability, and yet it's also true that a certain sector of the public has kind of enjoyed all of this. You know, it's sort of thrilling. It makes the hairs stand on your neck every morning to see what sort of madcap adventures are being engaged in every time you look at the internet. And it's a little bit like taking a ride in a souped-up DeLorean car back to the future. So I think that that's all really very interesting, and yet at the same time, if one cares to sort of parse the record, what's going on as well, in some ways, is a bit of a very great turning. And that very great turning is, first of all, on NAFTA itself. The president still tweets, and in fact has just tweeted earlier this week about ending NAFTA, but his views seem to be sort of discordant in the context of discussions that are going on. Just the other day, we also had press reports, and those of you who are involved in the trade area will know that on the TPP, the president wants to get back in and has instructed U.S. officials that he's interested in that. On the Paris Climate Change Agreement, he'd like to remain in the agreement if he can get a better deal. And on the Korea-U.S. Free Trade Agreement, he's already extracted some concessions, even if those are, in Dick Cunningham's notable words, totally cosmetic. So I think we have to remember that there are some very significant things going on, notwithstanding some of the heavy weather, the asymmetrical trade strategy that we are seeing today. And I think it's also important to remember that all of this is coming from a president who promised us on his inauguration day that from this day forward, a new vision will govern this land. From this moment on, it's going to be America first. Well, what did we have? In January at the Davos conference, that very same person issued a clarification and said, America first doesn't mean America alone. And one has to wonder what that means. Does that mean everybody else is second? It's not going to fly. And at the same time, even with these changes and turns, there seems to be a lot of sort of contrapuntal evidence, both within the administration and elsewhere, evidence that I think sort of coursed through our discussions today. I think that notwithstanding the turn, the great turn in the ship of state that may be taking place in this administration's position, there was some grudging acknowledgement by a number of people that the president's strategy, what Ambassador Jacobson called his rough justice, is in fact right. No matter how haphazard, no matter how much of a zigzag we may be viewing at the time being, it's a shrewd set of tactics. Now we have to be careful that that shrewd set of tactics, that zigzagging, doesn't get out of hand. As Jim Blanchard has reminded us, a full-blown trade war with China doesn't jive with the world's need of China to contain a nuclear North Korea. So on all sides, there's going to have to be some pragmatism and I think some give and take. There's just so much uncertainty at present. We were lucky to have a historical testament by none other than John Tennant, who told us that in the auto sector, at least, what's going on is kind of resonant with what happened 3 decades ago. Change the players around a little bit, and you've got something of a similar dynamic playing out. But the reality is that these tactics have already had some effect. They've already worked in part against Korea, as Dick Cunningham pointed out. It may be that the U.S. exemption on steel and aluminum tariffs may be used as a bit of a prod to get Canada and Mexico to agree to at least suspend the Nafta discussions on favorable terms to the United States that the president can take to his electorate and indicate to them that some progress has been made. Now, that has to be countenanced and that has to be assessed against the fact that, as Jeff Schott pointed out and reminded us, NAFTA has always been controversial. That's why we haven't fixed it before. And of course, another outcome could be that the passage of time simply means that at the end of the day, something like NAFTA may take second place to more immediate and emerging priorities and events, and that will be returned to or may not be returned to in 2019. But there has been no momentum right now in the sort of the political structure to get a deal done, no political will behind these changes. And if there had been, or if there was, maybe we could get some sort of interesting outcomes. For example, Jim Peterson mentioned in passing this morning that a solution to the current constitutional crisis in the WTO might be a requirement that consensus should not be required for every WTO issue. It takes some vision to do something like that. And it intriguingly would take us away from something like an America First position. But for the time being, what do we have? We've kind of got this limbo that, as Dan Utso pointed out, is a win for the president, something he can spin to groups that are in support of him. Now, the concern, of course, is that this limbo, attractive though it might be to the president, is something that will only go on for a while or can only go on for a while. We still haven't seen the full force of the ag lobby against venting its fury against Chinese retaliation, or a belligerent AMLO ensconced in Los Pinos, letting thousands and thousands of illegal immigrants cross Mexican territory and show up at the U.S. border, or a disinterested Canada that stands back and says, okay, let NAFTA fail. Because like Ambassador Jacobson said this morning, maybe the collapse of NAFTA may do less damage than is anticipated. So my point is that there's a time limit to what we're seeing, to all of this. And it's hard to see whether any of these changes and any of these discussions and any of these maneuvers, and you might even call them antics, are going to have in the long term an impact and make a difference for people in Indiana or Missouri or Alabama who have to contend with low wages and who believe that they have somehow been wounded by international trade. And this scenario seems to give credence to the view expressed by Minister McKay last night that we all share something in common, even if that common vision at the moment seems to be a little thin, a little threadbare, a little worn. And it seems to cohere with what he said, that there is no going back. There's no going back to the future, that we're all involved in this in common. We can't go back. We have to move forward together. And so these are some serious thoughts, perhaps, I hope perhaps not too somber, to think about as we come to the end of this 42nd annual conference of the Institute. In closing, I'd like to thank our sponsors, particularly our platinum sponsors, DLA Piper and Cleveland Cliffs, and our silver sponsors, Parker Hannafin, Formica, the Consulate General of Canada in Detroit, and the law firm of Steptoe & Johnson. I'd also like to thank my fellow co-directors, Steve Petrus of Baker Hostetler and his lovely wife, Colleen, who joins us here today. and especially to the Institute's indefatigable managing director, who many of you will have met, Ted Paran, both of whom he and Steve have worked very hard over the last few months to put this conference together, and they always do so with great efficiency and great aplomb. And in Ted's case, I think he gets most of his energy from his lovely Mexican wife, Adriana, and that's a small pitch to keep NAFTA together as a trilateral venture. And so I'd like to thank all of you very much. Merci beaucoup, muchas gracias, and safe home, and we look forward to seeing all of you next year. Thank you.
Kai, that was a great summary. Let me say thanks to the people that were thanked so properly by Kai. But let me also, Jimmy Blanchard can't be here, but he wanted me to give a real special thanks to the people from the university here who've made this possible on such a high level. Also, I want to thank, on behalf of Jim and myself and all of you, the people who have participated in our panels today. I thought every one of them was really good and really worthwhile, and I got writer's cramp taking notes. Thank you for imparting the wisdom and knowledge and experience that you have brought to this discussion, and thanks to the people who've attended, who have such a wealth of experience in many cases and knowledge. Having said that, I hope you get home safely and look forward to seeing you next year. Many, many thanks to all of you.
All right, one final thing before you all go. If for those of you who are able to stick around, we will be having dinner nearby in Little Italy, 6 p.m. So if you want to meet at the Glidden House, which is right across the street, just 10 minutes or so before, we'll have transportation available. If I could just get a show of hands for who thinks they might be able to join. You could walk, sure, the weather's great, but there is transportation. So, all right, thank you very much. And thanks everyone again for coming. It's been a pleasure.